Continued bad faith, malice, and coercion. A comprehensive argument following phone meeting with opposing counsel and pre-hearing judge. Claimant, Starchild. Date of injury, February 20th, 2025. Employer and insurance company, True Blue. Same entity. Third-party administrator, TPA, Gale Besson. Opposing counsel, Gale Benson and Heather D. McGraw, Pollard Miller. Physician under review, Dr. Daniel Bates, MD, Family Medicine, MBI Injury Care, Fort Collins, Colorado. IME date, July 9th, 2025. Introduction. A system under attack. The case of deliberate medical misrepresentation, unlawful coercion, bad faith, and malice. This submission presents a compelling and meticulously detailed challenge to the medical reports, specifically the treatment plan, issued by Dr. Daniel Bates, MD, following my visit on June 24th, 2025. It reveals not merely inaccuracies, but a deliberate, consistent, and escalating pattern of medical malfeasance, fraudulent misrepresentation, profound ethical violations, bad faith, and outright malice designed to subvert my legitimate workers' compensation claim. Crucially, the assertions made herein are not mere speculation or personal interpretation. They are based upon accurate knowledge derived directly from established medical literature, objective diagnostic findings, and relevant legal and ethical principles governing physician conduct, as outlined in the Colorado Workers' Compensation Act and Division rules. As publicly accessible information, these specific rules and regulations can be cited by anyone with access to these public records. This is not an isolated incident. It represents a calculated attempt to defraud the system and deny critical care to an injured worker. These pervasive delays, denials, and fraudulent medical opinions are not simply administrative failings. They are creating severe financial hardship and economic duress for me, amounting to a form of starvation that no injured worker should be subjected to. This unethical and allegedly illegal strategy to coerce claimants through financial distress must cease immediately. The responsible party should not be allowed to continue this oppressive conduct fueled by bad faith and malice, and must be compelled to comply 100% by law with their obligations to provide timely and appropriate medical care and compensation. 2. My undeniable pre-injury health and severe post-traumatic injuries. 1. Irrefutable pre-injury baseline. No degenerative age-related issues. In October 2024, while actively employed by True Blue companies, I successfully passed a federally mandated Department of Transportation DOT physical. This official certification confirmed no pre-existing conditions or degenerative pathologies whatsoever. My life history as a strong, very healthy male with no prior medical problems, combined with a physically demanding professional career, including 16 prior contracts, active performing with bands, and directing/producing Eclipse Nation shows, unequivocally refutes any assertion that my current debilitating conditions are due to pre-existing or age-related degeneration. My current severe medical conditions are directly, solely, and acutely attributable to the traumatic accident of February 20th, 2025, constituting an acute traumatic etiology. 2. The traumatic event. On February 20th, 2025, while working for True Blue at the Symbiotic/Walmart facility, I sustained a severe direct impact from an 800-pound piece of equipment that was intentionally dropped on me by a disgruntled employee. This specific acute trauma is the direct cause of my subsequent comprehensive medical conditions. 3. Confirmed post-traumatic diagnoses, objectively verified. Complex regional pain syndrome, CRPS, in the right upper extremity. This diagnosis was definitively confirmed by a radiologist via a 3D bone scan, aligning with the Budapest criteria for CRPS diagnosis. Autonomic storms and dysreflexia. Exhibiting severe autonomic dysregulation, a condition for which I received inadequate care for 4 months, underscoring its debilitating nature and neurological basis. Dystonia and allodynia. Documented severe neurological symptoms characteristic of central sensitization and abnormal motor control. Torn tendon/underlying tears in the upper right extremity/rotator cuff region, accompanied by a significant hematoma. Extensive cervical spinal pathology, objectively confirmed by an MRI, ordered by Dr. Bates himself, showing cervical spondylosis with protrusion/osteophytes at C4 to 5, C5 to 6, and C6-7, central canal stenosis and foraminal narrowing, mild canal stenosis and moderate left foraminal narrowing at C4-5, moderate central canal stenosis, severe left foraminal stenosis, and moderate right foraminal stenosis at C5-6, mild canal narrowing at C6-7, and critically, a linear hyperintensity in the spinal cord at the C6-7 level, consistent with a prominent central canal or a small syrinx. This finding is indicative of syringomyelia, a severe, often progressive neurological condition involving a fluid-filled cyst within the spinal cord, frequently associated with trauma. 4. Concurrence of medical professionals. Importantly, 3 other treating physicians have consistently and independently attributed my comprehensive medical conditions, including the diagnosed CRPS and spinal pathology, directly to the work accident, affirming the causal link. 5. Deliberate obstruction of full diagnostic imaging, a breach of standard of care. Despite my entire right upper extremity being profoundly affected by the injury, only partial imaging has been performed, directly impacting diagnostic completeness. The cervical MRI was conducted without contrast. However, the medical imaging facilities themselves explicitly stated that if my conditions did not improve, it was highly recommended that the images be done with contrast. Given the complex neurological symptoms and the critical finding of a suspected syringomyelia, syrinx, the lack of contrast severely limits the diagnostic clarity and a full understanding of the pathology. Medically, contrast is often indicated in such cases to assess inflammatory processes, tumors, or the full extent of spinal cord involvement. Since day 1, I have repeatedly requested a full MRI and an arthrogram of the entire right upper extremity, from shoulder down to my hands, to comprehensively assess the torn tendons, underlying tears, and full extent of soft tissue and articular damage. These critical diagnostic tests, particularly the arthrogram, which provides more detailed visualization of soft tissue and joint structures, have been repeatedly refused for 4 months. Significance. This systematic and prolonged refusal to perform necessary and comprehensive imaging, both full extremity and a contrast-enhanced cervical MRI, as recommended by the imaging facilities themselves, constitutes a breach of the accepted medical standard of care. It is a deliberate act of diagnostic obstruction, actively suppressing objective evidence to minimize the documented severity of the injury, and thereby limit the employer/TPA's liability, a clear act of bad faith and malicious denial, despite clear clinical indications and the patient's persistent, medically sound requests. 3. Dr. Daniel Bates, an unqualified instrument of denial, breach of fiduciary duty, and malicious intent. Dr. Daniel Bates, MD, works at MBI Injury Care in Fort Collins. His primary qualification is as a family medicine physician. Lack of essential specialization. Dr. Bates is not a board-certified orthopedic surgeon, neurosurgeon, neurologist, or pain management specialist. My injuries, including CRPS, spinal cord involvement, syringomyelia/syrinx, severe spinal stenosis, autonomic storms, and dystonia, are highly complex neurological and orthopedic conditions that fall far outside the general scope of family medicine. Inadequate expertise and negligence. His medical opinions on the causation, comprehensive diagnosis, and appropriate treatment of these severe and specialized injuries are fundamentally without foundation or authority. His reports and actions demonstrate negligence, a profound breach of the standard of care, and appear to be driven by a malicious intent to misrepresent my condition within the workers' compensation framework. He is unable to provide competent medical management for my diagnosed pathologies. IV. The unfolding pattern of fraud, obstruction, bad faith, and coercion. A timeline of deception. Dr. Bates's actions are not errors. They represent a calculated and escalating pattern of misconduct aimed at subverting my claim. This pattern constitutes professional misconduct, ethical violations, and active acts of bad faith and coercion that directly compromise the integrity of the physician-patient relationship and the workers' compensation system. 1. The initial attempt at fraudulent reporting. First visit, June 16, 2025. Following my first visit on June 16th, Dr. Bates's office was hesitant to provide his initial report, requiring me to ask several times between June 17th and June 19th before it was finally emailed. On June 19th, 2025, after I returned home from my MRI, which took place on the 19th, I received and immediately discovered that this first report contained fraudulent inconsistencies and deliberate factual misrepresentations. These inconsistencies were not mere errors. They contradicted what other doctors had said, and crucially, even misrepresented how the accident happened, a direct attempt to alter the factual basis of my injury causation. On June 20th, 2025, I immediately called Dr. Bates's office out on this fraudulent material. I explicitly informed them that these corrections were mandatory for the Division of Workers' Compensation and opposing counsel, Gale Benson and Heather D. McGraw of Pollard Miller, representing True Blues/Gallagher Bassett. This external pressure ultimately forced them to correct the fraudulent material. Significance. This incident establishes a clear precedent of Dr. Bates's willingness to engage in fraudulent reporting, driven by bad faith from the very beginning. Had I not been diligent, vigilant, and possessed the ability to meticulously read and interpret medical reports, this initial fraudulent account would have become the official record, allowing them to fraudulently get away with misrepresenting my injury and its cause, directly impacting the compensability of my claim. 2. The retaliatory and manipulative second visit, June 24, 2025, 1:20 p.m. Pre-existing anger and unprofessionalism. Upon entering the examination room, Dr. Bates was visibly angry with me. This anger stemmed directly from being held accountable for his prior fraudulent reports, which I had forced his office to correct. The fact that I had an adverse allergic reaction to gabapentin, a medication he had prescribed, which I had legitimately reported to both the Division of Workers' Comp and opposing counsel. His argumentativeness during the visit, as I consistently demonstrated a superior knowledge of my own medical records compared to his, forcing me to ask him 3 times to cease arguing. This constitutes unprofessional conduct, a breach of patient respect, and indicates his malicious intent, improper communication and collusion, breach of due process and ethical violations. On the morning of yesterday, June 24, 2025, I participated in a pre-hearing with a judge and opposing counsel, Gale Benson, and Heather D. McGraw, where I presented 4 specific pieces of evidence, A to D, and my overall health history. Later that same afternoon, yesterday, June 24, 2025, starting at 1:20 p.m., Dr. Bates entered my examination room. He had no prior paperwork of his own, yet he possessed specific, detailed knowledge of the evidence I had only just presented in that private legal proceeding that morning. This information had not been discussed with him directly by me. Significance. This constitutes undeniable and direct evidence of improper, collusive, and ex parte communication between Dr. Bates and the employer's TPA's legal team. It proves he is operating as an agent for the defense, actively receiving privileged information to subvert my claim, rather than acting as an independent medical evaluator fulfilling his fiduciary duty to the patient. This is a clear act of bad faith and malicious coordination. Crucially, had I received Dr. Bates' new report, or seen him on Monday, June 23rd, prior to the pre-hearing, I would have immediately brought up his fraudulent treatment plan to the judge yesterday morning, when she asked for any further demands. The timing of this new report's issuance, and my visit with him, was clearly orchestrated to prevent this immediate judicial challenge and scrutiny, a clear act of coercion. Strategic scheduling to influence IME, an act of coercion. Dr. Bates explicitly asked me for the exact date of my upcoming IME for the insurance company, scheduled for July 9, 2025. He then deliberately ensured his office scheduled my next appointment with him for July 7, 2025, just 2 days prior to the IME. Crucially, there is no actual treatment plan or specialist visit scheduled for me between my visit on June 24th and July 7th. My medical condition is not expected to change in any way to justify a medically necessary follow-up appointment with him. Significance. This tactical maneuver clearly reveals the July 7th appointment has no legitimate medical purpose. Its sole intent is to generate the most recent, biased medical documentation to improperly influence the IME outcome in favor of the employer/TPA and Gallagher Bassett, another clear act of coercion within the system. Rushed and predetermined treatment plan, the new fraud driven by Malice. Instead of preparing a comprehensive narrative report after thorough consideration, which is typically due later, Dr. Bates drafted his treatment plan in his office, which was then immediately sent to the lobby to be given to me while I waited. Significance. This hasty preparation, combined with the alarming content within, confirms a predetermined agenda to quickly disseminate a new, biased narrative before external scrutiny could challenge it. This treatment plan itself is the new vehicle for fraud, demonstrating an active effort to control the medical narrative with malicious intent and bad faith. The new fraud. Dr. Bates' latest treatment plan, June 24, 2025. A manifestation of bad faith. Dr. Bates' current treatment plan is not a legitimate medical document, but a thinly veiled attempt at further misrepresentation. These identified inaccuracies, omissions, and false claims are not speculative. They are demonstrably incorrect based on objective medical evidence, established medical diagnostic criteria, and fundamental principles of medical causation. His report constitutes unscientific and unprofessional medical opinion, clearly demonstrating bad faith. 1. Falsehood regarding central stenosis. He audaciously states my MRI shows moderate degenerative changes without significant central stenosis. This is a direct, provable falsehood. My MRI report explicitly details mild, moderate, and mild central canal stenosis at C4 to 5, C5 to 6, and C6 to 7 respectively, along with the critical C-ring/prominent central canal at C6 to 7. This is a blatant misrepresentation of objective diagnostic imaging findings, an act of bad faith. 2. Unsubstantiated denial of causation. He claims overall the degenerative changes in the cervical spine would not explain the ongoing right upper extremity issues. This statement is medically unsound and defies common understanding of spinal neurology. My confirmed CRPS, dystonia, allodynia, and torn tendons are directly linked to the extensive cervical spinal pathology, stenosis, and syringomyelia, caused by the trauma. His claim attempts to fraudulently sever this clear medical causation, contradicting accepted medical science regarding spine-related radiculopathy and myelopathy, demonstrating further bad faith. 3. Deliberate omission of critical spinal cord pathology. He conspicuously omits any meaningful discussion of the linear hyperintensity/C-ring syringomyelia at C6-7 in his report. This omission of a serious neurological finding, objectively confirmed by MRI, is a deliberate attempt to minimize the severity, nature, and long-term implications of my work-related injuries. This is a gross dereliction of diagnostic reporting, driven by bad faith. 4. Unnecessary reevaluation of confirmed CRPS. His recommendation for further CRPS evaluation is redundant and serves no medical purpose given my definitive diagnosis by a radiologist via a 3D bone scan, which aligns with accepted CRPS diagnostic criteria. This is a clear tactic to create doubt, delay appropriate treatment, and unnecessarily prolong the diagnostic phase of care. A further act of bad faith and coercion through delay. 5. Fraudulent attribution to age. His attempt to attribute my condition to degenerative changes related to age is definitively disproven by my DOT physical from October 2024 while working for True Blue, which confirmed no pre-existing conditions. My current severe symptoms are acute manifestations directly resulting from the trauma. This constitutes a false and unsubstantiated medical opinion intended to deflect responsibility for the work injury, a clear act of bad faith. VI. Relevant state and federal legal protections for injured workers against wrongdoing, bad faith, malice, and coercion. The actions of Dr. Bates, the employer, True Blue, and the insurance company, Gale Besson, appear to violate various provisions established to protect injured workers. These include, but are not limited to, the following examples from Colorado and federal law that are publicly accessible and citable by anyone. These statutes and rules collectively aim to prevent and punish acts of bad faith, malice, and coercion in the workers' compensation system. A. Colorado State Laws. Colorado Workers' Compensation Act, CRS Title 8, Article 40 to 47, and Division Rule 7 CCR 1101 to 3. Duty to provide medical aid. CRS Section 8421013A. This statute mandates that the employer and insurer furnish such medical, surgical, dental, nursing and hospital treatment, medical, apiary, and serotherapeutic supplies, crutches, and every artificial member, glasses, and eyewear as may reasonably be needed to cure and relieve the injured employee from the effects of the injury. Deliberate misrepresentation or obstruction of care by an authorized physician, driven by bad faith or malice, directly undermines this statutory duty. Prohibition against false statements. CRS Section 843404. While often applied to claimants, this broad statute makes it a felony to willfully make a false statement or representation relevant to a workers' compensation claim for the purpose of obtaining benefits, payments, or compensation to which you are not entitled. A physician knowingly making false or misleading reports on behalf of an employer or insurer to avoid their obligations could potentially fall under the scope of related anti-fraud provisions or be considered aiding and abetting such violations, particularly when demonstrably done with malice or in bad faith. The Colorado Department of Labor and Employment explicitly states that employer fraud is characterized by knowingly misrepresenting the truth to avoid, deny, or obtain compensation on behalf of an employee. Physicians' reporting requirements. 7 CCR 1101 to 3, Rule 11 to 1D. This rule outlines the requirements for medical reports, emphasizing that they must be accurate, complete, and timely. Dr. Bates' documented omissions, misrepresentations, and delays in providing accurate reports, especially when coupled with evidence of bad faith or malice, directly violate these regulatory requirements for medical providers in the workers' compensation system. Medical fee schedule and treatment guidelines. 7 CCR 1101 to 3, Rule 11 to 2A and C. These rules govern the scope and necessity of medical treatment and diagnostics. The repeated denial of medically indicated diagnostic imaging, full MRI/arthrogram of extremity, contrast cervical MRI, suggests a failure to adhere to recognized standards of care and appropriate treatment. Such denials, when motivated by a desire to avoid legitimate costs and prolong a claim through coercion or bad faith, violate the intent of these rules. Good faith requirements. While not a single statute, the overall framework of Colorado workers' compensation law implies a requirement for all parties, including employers, insurers, and their chosen medical providers, to act in good faith throughout the claim process. Actions demonstrating bad faith, such as deliberate misrepresentation, collusion, obstruction of care, and the imposition of financial hardship as a form of coercion, fundamentally contradict the principles of the system and may lead to legal penalties. B. Federal laws and principles. Occupational Safety and Health Act, OSHA. While primarily focused on workplace safety, OSHA, 29 U.S.C. Section 654, ensures a safe working environment. The incident itself, particularly if a disgruntled employee intentionally dropped equipment, could highlight failures in workplace security, supervision, or addressing employee conduct, all of which fall under OSHA's purview. More broadly, employers are prohibited from retaliating against employees for exercising their rights under OSHA or for reporting workplace injuries, and any such retaliation could be interpreted as an act of malice or coercion. Federal anti-fraud statutes, e.g., 18 U.S.C. Section 1920, false statement or fraud to obtain federal employees' compensation. While this specific statute applies primarily to fraud within federal employee compensation programs, it reflects a broader federal condemnation of fraud in workers' compensation. Many states, including Colorado, have their own robust anti-fraud statutes, as cited above in CRS Section 843404. The principles articulated in such federal laws, criminalizing knowingly and willfully falsifying, concealing or covering up material facts or making false statements to obtain or deny benefits, are consistent across state workers' compensation fraud laws and directly address actions taken in bad faith or with malice. Americans with Disabilities Act, 8A, 42 U.S.C. Section 12101, (EDSA). While workers' compensation is distinct from the ADA protects individuals with disabilities from discrimination in employment. If an employer's actions, including through their medical providers or insurers, are perceived as discriminating against an injured worker because of their disability resulting from a work injury, it could potentially invoke ADA protections, particularly concerning reasonable accommodations or return to work. Actions demonstrating bad faith denial of accommodations could also be seen as discriminatory. Employee Retirement Income Security Act, ERISA, 29 U.S.C. Section 1001 (EDSA). Generally, workers' compensation plans are exempt from ERISA regulations if they are maintained solely to comply with applicable workers' compensation laws, as stated in ERISA Section 4, B3, 29 U.S.C. Section 1003 B3. This means federal ERISA protections regarding benefit plans often do not directly apply to state workers' compensation claims. However, the general principles of fiduciary responsibility and avoiding self-dealing, which are central to ERISA, align with the ethical principles expected of all parties in any benefit system, including workers' comp. Deliberate acts of bad faith in managing claims run contrary to these broader ethical expectations. 7. Conclusion. Demand for justice and integrity in the workers' compensation system against bad faith, malice, and coercion. The cumulative evidence overwhelmingly demonstrates that Dr. Daniel Bates is not an impartial or credible medical professional in my workers' compensation claim. His actions, from documented prior fraudulent reporting and hostile demeanor, to his current medically inaccurate and strategically manipulative reports, clearly indicate a physician operating as an agent for the employer's TPA, Gallagher Bassett, and their legal counsel, Gale Benson and Heather D. McGraw of Pollard Miller. This behavior fundamentally undermines the ethical standards and integrity of the entire workers' compensation system, violating the spirit and potentially specific letter of the laws and regulations designed to protect injured workers in Colorado. It is absolutely unacceptable for True Blue, Gallagher Bassett, and their counsel to continue these tactics, which have resulted in severe financial hardship and economic distress, amounting to a form of starvation, in an attempt to coerce me. This conduct, characterized by bad faith, malice, and coercion, is unlawful and must cease immediately. I respectfully demand that the Division of Workers' Compensation take immediate and decisive action. 1. Immediate removal of Dr. Daniel Bates as treating physician/main caretaker. Dr. Bates has demonstrated an irrefutable conflict of interest and breach of fiduciary duty through direct, improper communication with opposing counsel, indicative of bad faith. His reports contain fraudulent misrepresentations and omissions of objective medical findings, demonstrating a deliberate intent to mislead and deny proper care, a clear act of malice. His medical opinions are based on unscientific and unprofessional judgment, falling far below the accepted standard of care for complex neurological and orthopedic injuries, further demonstrating bad faith. His hostile and argumentative demeanor constitutes unprofessional conduct and a breach of patient trust, making a therapeutic physician-patient relationship impossible, showing malice and intent to coerce. His continued involvement directly jeopardizes my health by obstructing proper diagnosis and treatment. He cannot, and does not, act in my best medical interest, thereby violating the fundamental principles outlined in the Colorado Workers' Compensation Act, requiring furnishing of reasonably needed medical aid, CRS Section 842101-3A, and Division Rules on Accurate Medical Reporting, 7 CCR 1101-3, Rule 11-1D. 2. Immediately disregard and strike all of Dr. Daniel Bates's reports. Deem all his medical reports concerning my case unreliable, biased, and inadmissible for consideration in my claim. His history of fraudulent reporting and direct collusion, permeated by bad faith and malice, makes his opinions inherently untrustworthy. 3. Initiate a formal investigation into Dr. Bates's professional misconduct and violations of workers' compensation regulations. Conduct a comprehensive investigation into Dr. Bates's documented pattern of fraudulent inconsistencies, unprofessional behavior, and improper communication with opposing counsel. This should be referred to the Colorado Medical Board for review of professional and ethical violations, and to the Colorado Division of Workers' Compensation for review of alleged breaches of regulations, including, but not limited to, those mentioned in Section 6, e.g. CRS, Section 843404 regarding false statements, 7 CCR 1101-3, Rule 11-1D regarding reporting requirements, and broader principles of good faith. Such conduct, characterized by bad faith, malice, and coercion, compromises the ethical standards and due process of the workers' compensation system and potentially endangers other claimants. 4. Order a truly independent medical examination. IME. Appoint a new, highly qualified board-certified specialist, e.g. neurologist, neurosurgeon, or pain management specialist, with expertise in CRPS and spinal cord pathology for a new IME.